Viewers, welcome to this week's episode of The Law Lab. I'm Tony Carbone, the Managing Partner at Carbone Lawyers. Today I've got John Carancis, accredited specialist, partner at Carbone Lawyers in work cover and litigation. Good day, John. How are you?
Hi, Tony. How you going? And Joe.
And Joseph Carbone, a senior associate at Carbone Lawyers in work cover and TAC. Good day, Joe. How are you?
Good day, Tony. Good day, John.
Today, fellas and viewers and listeners, we've got an absolutely pertinent and critical and topical subject of evidence, and we're going to use the example of the George Pell case, John.
Oh, yes, Tony. It's vital in all court cases. Guess what? Evidence.
That's it.
It's so vital, it makes or breaks your case.
Of course. And Joseph, we're not here to sympathise with George Pell. We do sympathise with the victims of sexual abuse, of which this firm does represent a lot of plaintiffs.
Oh, yes.
Yes, absolutely.
And we're not saying George Pell's guilty because it's not our domain to do.
Well, the court found otherwise.
Yeah.
Well, absolutely not. I mean, this case has been extremely divisive in Australia, and probably not for the corona. If it wasn't for the coronavirus crisis, probably would make front page news around the world.
It made the first story in this morning's news. But look, viewers, the whole thing around this case that we want to highlight is we're civil lawyers primarily. We do a lot of litigation around compensation, commercial, etc., and family law. Now, what's critical, John and Joe, is that when you get before a court, you have to present facts.
It's all about the facts and your evidence, Tony. In the George Pell case, the OPP decided to prosecute him for criminal charges in relation to rapes that occurred 20 or 30 years ago. Now, in the criminal context, you have to prove that beyond a reasonable doubt.
Yes. And now, just on that point, the evidence, just assume for 1 minute the evidence is after the mass was over, the service was over, in a window of 5 to 6 minutes, George Pell assaulted the victims in his chamber. The evidence also is that after he delivered his service, he'd go out there and greet the parishioners. Now, a 5 to 6 window, is it conclusive? Anyway.
Well, look the thing that a lot of people have a hard time getting their head around is the actual standard of proof that we have in Western societies being beyond reasonable doubt. Now, it doesn't mean that it didn't actually occur. It means that you can't have a reasonable doubt in your mind for someone to be convicted of a crime. And that's a very high standard to hold.
And 7 High Court judges determined that in this case, a reasonable jury would have had a reasonable doubt.
Yes.
In the circumstances and the evidence that was presented by the OPP. Tony, you have to remember that the first jury that heard this case could not reach a decision.
That was a hung jury.
It was a hung jury.
Yeah.
And that was all in secret. The second jury found against Mr. Pell, Archbishop Pell, and convicted him. Then you have the Court of Appeal, the Victorian Court of Appeal, 3 senior Court of Appeal judges, 2-1.
Found that he was.
So it wasn't a unanimous decision there. It was 2-1, found him guilty.
Yes.
And then it's gone to the High Court, and the High Court 7-0. Tony, 7 High Court judges have looked at the circumstances of the evidence that's been presented, and that's what we're talking about here today, everyone, the evidence. And
that was
found
before the court.
That was before the court and nothing else. And that's where I think a lot of the hysteria is on about, that everything else that's happening with the Catholic Church. The court is here to determine the evidence against
in this case,
Archbishop Pell. Nothing more, nothing
and not
less.
what he did or didn't do in the past.
That's actually a very good point because, George Pell's supporters have probably said that he's been prosecuted for things that he did or omissions, things that he didn't do
in the past
over the years, presiding over the Catholic Church.
Which is not relevant to this proceeding.
That's
But what's critical is in our system of justice, the freedoms of the individual are first and foremost paramount, correct?
Well,
we are all presumed innocent until proven guilty.
The Americans, who have a very similar system to us, like using the adage that they'd rather have 99 people acquitted than having one person found guilty who's actually innocent. And I guess that cause a lot of confusion and dismay in our community a lot of the time. But,
Tony,
without-
Tony, in the end,
yeah.
in the civil context, again, when we run a damages trial in a Supreme Court, us as a practitioner, we have to provide evidence.
Yes.
The onus is on the plaintiff, just like the onus was on the OPP against Pell.
To prove his guilt beyond reasonable doubt.
And
Yes.
in our civil context, in work injury claims, in car accident claims, we have to show, as in the victim, that on the balance of probabilities. So it's a different test.
It's a lot lesser test. But having said that, one of the things that we need to do is we need to make sure that when these injured people give evidence, that they've been consistent in terms of their presentation to all the doctors, any statements they've given, any documentary material they've presented.
It's in the preparation of the claim and,
Yes.
and the preparation of the witness, as in the plaintiff giving evidence. And the plaintiff has to have, in essence, a story that is the same all along.
Yes.
Any inconsistency
is where they get shot down.
will be jumped on by the defendant, or in Archbishop Pell's case, by the prosecution,
course,
in saying, well, what? You're lying or misleading here, and you're not lying or misleading on the other item. Which one is it now?
Yes.
So the credit of the witness is vital, isn't it,
Of
Tony?
course it is. And Joseph, in relation to our plaintiffs that go to court, what's important is that when the judges decide these cases, they actually take parts of medical reports, parts of a plaintiff's evidence, parts of a witness's evidence, any experts, engineers, etc., and they summarise that to get to their conclusion. That's why in our system we're fortunate, because when it's a judgment by a judge, you can go through it and see if they got it right. And if you think they got it wrong, you can appeal it. Sadly, when there's a jury involved,
very difficult to appeal.
they do not provide reasons.
Yes.
That becomes complicated, doesn't it?
Absolutely. And look, the jury system's still a major component of our justice system. Some people say that we should do away with juries. Other people say that it's a cornerstone of our system. And yes, I mean, one of the issues is that appealing a jury verdict is very, very difficult.
Well, John, it's got to be perverse. It's got to be perverse, which no reasonable jury could come to that conclusion, which is not very easy to overturn, is it?
Not easy to overturn. However, as in the case of Archbishop Pell, 7 High Court judges literally determined that the jury got it wrong.
But in a criminal context, it's beyond reasonable doubt. In civil, it's balance of probability, so it's even harder to overturn, I would have thought.
Well,
but look, can I say
exactly.
this? What's critical is that the plaintiffs are consistent and they document everything, and every person they talk to has to be the same. They can't give a bit of a story to one doctor, a bit of a story to another doctor.
Look, that
part of a story to an independent...
An injured worker, his story has to be pretty similar...
all around, all along.
To doctors, to treaters, to medico-legal experts, and to the engineer, Tony.
And this is the advice I give to clients. What you do is, if a third person's looking at you, you don't want them to turn around and say, "Hey, geez, this is what they're doing is contradicting the fact that they've got a serious back injury."
Well, judges
like you wouldn't
don't
be jumping around or dancing or running, correct?
Judges don't like witnesses that embellish, that mislead, that exaggerate. And we advise all our clients, don't we, Tony, just to say it as it is.
I guess exaggeration's a big one, because I guess we all have a tendency from time to time to exaggerate things.
Yes.
It's just a natural human trait, but in the courts, and when you're looking at it from a legal point of view, it can be very problematic and can penalise people that may not actually be doing something
So basically
improper.
what we're saying is you can't understate it, but you can't overstate it.
Correct.
Don't overcook anything and don't undercook it. Look, getting back to the George Pell scenario, look, the reality is this. We're not here to cast aspersions about whether he did or didn't do it. The reality is we've got a victim who's the only person that could give evidence about what happened on the night in question, okay? And you've got George Pell, who hasn't given a version, because in the criminal law, the defendant does not have to give evidence.
Doesn't have to give evidence.
Yes.
His testimony and questions before police officers in Rome was presented to the court and considered by the jury and the court. So that part. But yeah, it's interesting, Tony. A lot of criminal lawyers always say that the defendant, in order to protect their claim or to protect their rights, should not give evidence.
Yeah, look,
I have to admit, I'm one of those people who would say no. If you want to vindicate yourself, you should give evidence.
I think the reason why they did it in this case, John, is that, you got to prove beyond reasonable doubt. And the reality is you got one person saying what they had to say. You got no other version. So 5 to 6 minute window to commit these crimes in very sort of...
Look, I don't think there's any winners from this situation. Yeah. I mean, it's a very unfortunate set of circumstances. And, look, if you look at the person who made the allegations and the person who gave evidence against Pell, I mean, he wouldn't be in a situation where he's this litigation, and in terms of being through 2 county court trials, a Victorian Court of Appeal and then a High Court trial. It's a very, very difficult situation.
And that's a very good point you make there, Joe. You know why? Because bottom line, it's not as if the High Court had come back and said that the witness was lying.
No.
They've just said that he's presented his evidence, but we still can't be satisfied beyond reasonable doubt that it occurred.
That guilt is established here.
Yes.
Tony, apart from the Lindy Chamberlain case, this is probably the most contentious decision that has come out in the last 30 or 40 years, isn't it?
I'd agree with that.
Now, Archbishop Pell has been in jail for over 400 days.
Yeah, I thought about that.
He now has a claim against the OPP for malicious prosecution.
He potentially has a claim, but I'd be very surprised if he'd pursue his rights. And look, the reality is, any which way we cut it, when you start looking at reasons why a jury would have found him guilty, the reality is their own personal prejudices and speculation, innuendo about his time when he was in Ballarat, and he had Risdale, who turned out to be one of the worst pedophiles.
There's a Royal Commission report that will come out very shortly that will expose and detail his conduct in regards to all that matter. But Joseph,
but that should have been taken into account in this case, John. And realistically,
no, it was
a jury
excluded. Yeah, because it was too prejudicial. It was actually excluded.
But a jury probably still took it into account. You'd never know because they're not asked questions.
No, but that evidence was actually not provided.
Of course.
We, Tony and Joseph, we act on behalf of quite a few people, sexually abused people, against not only the churches but various orders.
Even family, John. There's a lot of instances where they've been abused by
family, but
family. You know what I mean? Which is really sad.
What we can say is you should always pursue your rights. You've got entitlements. The state of Victoria has waived the statute of limitations in respect of sexual abuse claims. At Carbone Lawyers, we're expert in this type of litigation. We sympathise with your plight, and we're here to assist and help you.
And John and Joe, these victims, my God, they're pretty seriously traumatised, aren't they?
Of course.
Absolutely.
They are very, very...
it's changed their life.
Yeah, you sit them down, you're trying to take them through the facts. A lot of them break down. A lot of them are aggressive.
It changes their lifetime.
Yeah,
they're on medication for years and years.
It impacts on all their relationships moving forwards with spouses and children and all sorts of things. Even their interactions with the public in general, employers, employees.
And with a lot of our clients, Tony, as you know, it's not about the money. It's about the vindication.
Yep.
It's about being vindicated that your story has been heard and been dealt with and not ignored, which it was for years and years.
Of course. And also, I want to go to the example of the case you ran at Butchich where he fell off a scaffold, John.
Yes, Tony. We've got a worker here that fell off a scaffold, wasn't really sure what happened because guess what? He suffered brain damage to a certain extent and spinal injuries, but he fell off a scaffold.
And what did his former lawyers try to settle his case for?
Not a lot of money.
And then you got the engineer involved. You ran the case.
We ran the case. We prepared the case properly. We obtained updated medical reports.
We pieced it together as best as we could with the evidence we had. Correct.
This is where you have to literally reconstruct what happened to the best of your ability, present your case to the court, and the court
Has to make a decision.
Made a decision of over $1 million.
Yeah, we got this one here, Joe. We got $1.4 million. Look, I liken a person's case, Joseph, to a jigsaw puzzle. You come in and we start piecing together the puzzle.
Exactly.
Yes.
We get the evidence, which is your story, medical reports, witnesses, photos, engineers' reports.
And luckily, there were contemporaneous photos.
Of course.
And witnesses. That is vital,
Yes.
isn't it, Tony?
Yes.
Witnesses.
And Joe, the system generally works okay, doesn't it?
Yeah, look, I think that our justice system in Australia has its pitfalls, but yeah, I think that it does work, pretty well in most circumstances.
Tony, we're lucky to have the compensation system in Victoria. There's a lot of other countries in the world that don't have it.
Yes.
Look,
So
the other
we are
thing,
lucky.
One of the things I keep umming and ahhing about and always saying, it's important. You must get advice from a specialist and someone that knows what they're doing. And realistically, you need to speak to a lawyer that's actually been in a court case.
Always.
A lot of these lawyers haven't run cases, have they, John?
And that have experience.
Yeah. The important thing is if you go to someone that's never, let's say you go to a surgeon, he's done 1 or 2 operations, I'll tell you what, you're putting yourself at risk.
Always.
You'd think. Look, they've got to learn somewhere. You could be the guinea pig, unfortunately.
No, you don't want that because you only have viewers, clients, you only have one shot.
And if you muck it up, it's all over for you.
That's it.
Joe, is there anything else you'd like to add?
No, look, I mean, apart from George Pell's verdict, I mean, people shouldn't be disenchanted with the legal system.
Too judgmental.
I mean, look, this is one of the cases, probably less than 1% of the cases where it's been appealed on 2 separate occasions. I think that people that have been through this type of abuse should still come forward, most definitely.
Oh, yes.
Just because George Pell's case ended in the way it did doesn't mean that your stories won't be heard and won't be believed and justice won't be prosecuted just because of that.
Each case is treated individually on its own merits and separately, Tony.
And look, the thing about this decision by the High Court, they haven't turned around and said that the victim was lying. They've just said that, unfortunately,
there's not
under
enough.
our standard of beyond reasonable doubt, there's got to be some doubt. That's what they've basically said. So they're not saying anyone's lying. Bottom line, it is what it is. That is our test. And everyone sympathises with the victims.
Very unfortunate series of events in this case.
And, realistically, a jury could have taken into account all the speculation, innuendo, and everything that transpired in the past, John.
Exactly.
Isn't that right? All right, look, we've come to the end of the podcast, guys. Joseph, thanks for coming on board. John.
Thanks, Tony.
Thanks for coming on board.
Seeing you.
Viewers, thanks for watching and listening. Go to our social media platforms of Facebook, YouTube, Twitter, Instagram. Do all of that. Actually, my LinkedIn, I'm going to put it on that as well. And stay tuned for future episodes of a podcast. And please remember always to stay safe.